Well, I hope you have your voices in shape. We're going to be doing a little singing today. For those of you who can't quite put the gag together, you see, it's pad thai is a kind of Thai food, but iPod Thai is actually a conglomeration of two different thoughts we're going to be sharing with each other today, specifically about U.S. Apple and Kirtsaeng versus John Wiley. And if we have time, there'll be a couple more. Okay, so the four things that I'm going to try to cover, the first two in somewhat more detail than the last two. Okay, so we've got U.S. Apple, which is the case brought by the U.S. government against Apple and a group of publishers relating to the fixing of prices of e-books, of trade books in the consumer market. Kirtsaeng by John Wiley, which relates to the first sale doctrine, which I'll go into in considerable detail. And then I want to touch on the Georgia State University case, which relates to e-reserve practices, and the ongoing case of the Google Books project. So the United States versus Apple case relates to the U.S. government brought this lawsuit against Apple. And what did it relate to? In 2009, according to the complaint, the publishers in the United States were horrified to discover that Amazon was selling e-books at a flat, or at least most e-books, at a flat $9.99. And this was having, or was perceived to have, a substantial effect upon the pricing modalities of the publishers with respect to hardcover books, paperback books, and in general, it was a problem for them. So they tried to think, well, how can we deal with this? So they allegedly hatched upon the scheme suggested to them by Apple of imposing an agency agreement model. Now, in the United States, under antitrust laws, a manufacturer is not supposed to set the price at which its customers resell their products at. Now, this changed a little bit a couple of years ago by a Supreme Court decision, but in general, it's still a problem for a manufacturer to tell a customer, like a wholesaler or distributor, you have to resell at a certain price. But if they use an agency arrangement, where in effect they're not selling the book to their first line customer, but they are entrusting it to them to resell or to sell the first time, then they can set the price. Well, so this was the idea. They entered into an agency agreement whereby the publishers would in effect have an arrangement with Apple or Barnes & Noble or Amazon, that they would be agents of the publishers, so that the publishers could tell them, you can't sell below a certain price. So this arrangement actually went forward, and everybody signed up. Apple was just thrilled because they had been wanting to introduce electronic books into their iPads, hence the name of our little program today. So they wanted to introduce them through their e-book store, but they needed to have the prices a little higher than $9.99 in order to get it up off the ground. So this whole arrangement, again according to the complaint, goes forward, and when Apple opens up its e-book stores contemporaneously with the effective date of this agency agreement, the prices of e-books around the country jumped up 30 to 50%. People complained to the U.S. government. The U.S. government, Department of Justice, investigated and came to the conclusion that there had been a collusive arrangement between the publishers and Apple, and that this had the effect of fixing the prices. Now, keep in mind, a manufacturer could make its own decision as to whether or not to introduce an agency agreement. But a group of manufacturers cannot agree among themselves as to how they're going to sell their books or the price they're going to sell the books at. So that's what the government attacked. And so they bring the lawsuit in April of 2012, and simultaneous to the bringing of the lawsuit, there is an announcement that 3 of the publishers, Hachette, HarperCollins, and Simon & Schuster, have agreed to enter into a settlement with the government. Now, this was not a criminal case. It's not that these guys agreed to plead guilty. This was a civil case. And so they agreed that they would stop doing what they had been doing. Now, in order to make this settlement effective, it had to be approved by the court. So the court publishes the notice of this settlement, and there's a ton of responses from the public. Well, I'm not sure about the public. There was a lot of responses from people who were interested in the whole business of books. And these documents get filed. The court reads all these things dutifully and comes to the conclusion that despite overwhelmingly negative comments, of the several hundred comments that were filed, there were only about 70 that were in favor of the agreement. But the court came to the conclusion that this made sense to allow this settlement to go forward, because the court had already accepted the proposition that the complaint stated a cause of action. Not that the court had found that this is what happened, but that all the legal requirements to bring a lawsuit had been met. And if these people wanted to settle out, that was their right. And the court's approval order said, by disallowing the settling defendants from using the agency model for at least 2 years, and from using price MFNs, those are most favored nations clauses, for at least 5 years, the proposed final judgment appears reasonably calculated to restore retail price competition, i.e. competition between Apple and Amazon and Barnes & Noble and other sellers of ebooks, to restore this competition and return prices to a competitive level, benefit ebook consumers and the public, at least as to the competitive harms alleged in the complaint. So that's what the court says. That's okay. You guys can settle. Now, Apple has not settled. 2 of the other publishers have not settled. And they're supposed to go to trial next year. We'll see what happens. They may be taking a settlement as well, but no one knows what's going to happen right now. So the question is, does the Apple case mean anything to libraries? Now, libraries are not buying trade books off of Amazon, because if you buy it off of Amazon, you can't do anything with it. You can't lend it. It's going to go on, one copy of an ebook, or excuse me, of a reader. So, but there are more and more opportunities for libraries to buy electronic books that they can lend out. There's a lot of restrictions. Apparently not all publishers will sell them to you. And when they do sell them, they sell them at 2, 3, 4, 5 times the price that you could buy it from Amazon if you were a consumer. So the question is whether all this litigation that's going on regarding Apple and the publishers is going to have any positive impact upon the ebooks for libraries. It's hard to know right now, but obviously a lot more attention has been devoted to this area by the government, by the Department of Justice. And if there is some collusion perhaps that has gone on with respect to the pricing to libraries or the policies regarding libraries, that may come to light if this trial goes forward. I don't know that there has been. I'm not suggesting there has been. But it's something to follow because it may have an effect. So in order to kind of lock this into your memory, we're going to have a little bit of a musical summary. I'm going to need your help here on the choruses. You'll, with apologies to Burl Ives and that famous American composer Anonymous, we're going to sing this song. Now, I know you know how it goes, so when we get to the chorus, I'm hoping that you'll chime in. I wish I had an apple a-sitting on my knee, and every time an e-book passed, I'd take a bite for free. The first I seen a Kindle, the guy next door had one. He loaded Times bestsellers up and turned it on to run. Get along home, Kindle, Kindle, get along home, Kindle, Kindle, get along home, Kindle, Kindle. Will you stay cheap for me? I wanted so to own one, but worried about the price. I feared that $9.99 just might create a vice. The publishers agreed to, and so did Apple Inc. An agency agreement became the missing link. The prices escalated. They jumped up overnight. The antitrust division felt that just wasn't right. Some publishers have settled. Reactions, though, were mixed. The court upheld the lawsuit, said prices had been fixed. Get along home, Kindle, Kindle. Get along home, Kindle, Kindle. Get along home, Kindle, Kindle. Will you stay cheap for me? Book prices are adjusting. A few have now gone down, but Apple keeps denying and wearing quite a frown. Imagine you are Apple Inc., a-sitting by a tree, and every time a Kindle passes, you feel you need to plea. Okay, well, that was the iPad part of, and now for the tie part. That handsome gentleman there, this is from Mr. Kurtzang's website. He's got his own website. And so this is the lawsuit between Mr. Kurtzang and John Wiley. This gentleman moved from Thailand as a youth to go to school in the United States. He went prep school, then he went to Cornell, graduated from Cornell, and then went to USC for PhD studies in mathematics because he could add things up. He could, and he had a kind of flair for this because what he noticed was that the books that were being used at his university were also books that were being sold in his home country of Thailand, and in fact they were being sold for considerably less. And he locked in the concept, buy low, sell high. Now, you know that the fancy name for that is arbitrage, right? Okay, say that 3 times and it's yours for life. Arbitrage, arbitrage, arbitrage. So he had his friends and family ship books to him in the United States, which he would then sell over eBay or there's apparently a variety of other kinds of eBay-like things. And so he was selling these things. He bought low and sold high. And it was said that he had sold well over $1 million worth of books between 2007 and 2008. So it came to the notice of at least one publisher, John Wiley, that he was doing this. And so they brought a lawsuit against him, complaining of a little thing that we call copyright violations. So the case goes forward, and the judge enters an order saying that he can't raise the first sale doctrine because the first sale doctrine, to the judge, only applies to books that are made in the United States, and these books were all made overseas. These were Wiley books that Wiley had printed overseas for an overseas market and had stamped in effect all over it, only to be used overseas. But Mr. Kurtzang and his friends had shipped these books over to the U.S. So once the first sale doctrine was out of the case, Mr. Kurtzang really had no defense. I mean, there's no fair use doctrine. Oh yes, it's fair use. I just go buy these books and resell them. No, that was not fair use. So the case goes forward. The jury finds him to be liable for copyright violation, and he's fined $600,000. He appeals the case to the Court of Appeals for the Second Circuit. This was going forward in New York City. So he appeals to the Second Circuit, and the Second Circuit affirms the district court's opinion that this was not the fair sale. Not the first sale doctrine, doesn't apply. And remember what the first sale doctrine is sort of upside down. What the first sale doctrine says is the copyright laws no longer apply to the book or the other work of art that you have bought after it's sold to you for the first time. That's the first sale. When the first sale exhausts all the copyright rights of the owner of the copyright. But that's not applicable overseas, according to the District Court and the Second Circuit. So the Supreme Court decides they're going to consider this case. So they take certiorari, they issue a writ of certiorari. They held oral argument on it just last week. And it was a very interesting oral argument. My take on it, from reading the transcript, was that a lot of the judges were troubled by the failure to apply the first sale doctrine. Now, you can't always tell from oral argument where some judge is going to come out on a case. They may ask really, really tough questions just to kind of get set in their mind an answer as to why they're going to go the other way. So we don't really know. But this issue is whether or not the first sale doctrine applies to a work made overseas. Because conceptually, once a work is made overseas, it also is covered by U.S. copyright. And if the law says that the owner of a copy lawfully made under this title is entitled without the authority of the copyright owner to sell or otherwise dispose of it, what does lawfully made under this title mean? And this was the whole debate. What is lawfully made under this title? It's a terrible piece of legislative drafting. Who knows what that means? It doesn't, you know, in a lot of ways it means nothing. And so they say, well, it's used over here. Well, yeah, well, that's okay, because it doesn't mean anything over there either. So they're going back and forth about what's the best policy here. And I got to think right now that Wiley is really sorry that they brought this suit. You know, it's not about the $600,000. Now it's about a whole concept. And there was a lot of piling on from amicus briefs, American Library Association, the Association of Research Libraries, a whole bunch of museums, the Metropolitan Museum of Art. Everybody comes piling in on this in favor of Kurtzsang. I mean, nobody's saying, oh, what a nice guy Kurtzsang is. I mean, the guy was making a fortune off of this sale. And so he's a kind of unsympathetic figure. Nice looking guy, of course, but a little unsympathetic. But everyone else is saying, you know, this is going to cause terrible problems, because if you say stuff that was made overseas, if you bring it into the United States, the copyright is still held by the copyright owner. Well, does Picasso's heirs still own the copyright to the paintings that are now in the United States? That's what the museums were concerned about. Not particularly Picasso, but you know, any modern painting is still going to be under copyright, because when a museum buys a painting from some collector or whoever, they're not getting the copyright, they're getting the painting, the physical object, just like buying a book. And libraries are concerned. They say, well, geez, we probably have 200 million volumes of books that were made overseas. Are you telling me that if they're still in copyright, that I no longer can own this thing, that I can't use it, that I can't lend it? What a mess. And then there were just people coming along and saying, yard sales. My God, I was going to sell some books. My kids, you know, I was going to put my kid through college by selling his old high school textbooks. Can I not, and they happen to all have been printed in Thailand. Can I not sell those now? And one of the judges, Judge Breyer, who's a very well-respected justice on the Supreme Court, says, and Toyotas, what about Toyotas? A lawyer's saying, Toyotas? I don't know, what about Toyotas? And he says, well, they got all this computer stuff inside the Toyota, and it's copyrighted. If you bought this car and I brought it over from Japan, you know, it was copyrighted in Japan. Well, so now can you resell the Toyota? Oh, I don't know, Judge. That's an interesting question. So what's the Supreme Court going to do? Well, in my view, this is an example where easy cases make bad law. It's not that the issue is hard. the factual issue of Mr. Kurtzsang, he's not very sympathetic. Let's punish him for doing this. But if you adopt that rule, then it has all these other unintended consequences. And so when you actually read the briefs that were filed by Wiley and those supporting him, they're kind of like backpedaling and saying, well, libraries shouldn't worry about this. Museums shouldn't worry about it. Kurtzsang should worry about it, but not anybody else. So, is that so? But writing an opinion where that's going to take itself out into account is hard to know. So, the majority of the court has to decide whether or not to adopt, in effect, the so-called universal exhaustion doctrine, meaning you sell it overseas, copyright is exhausted everywhere in the world. That's a little bit tough to swallow. There's not a lot of countries that adopt that. It would make sense. It's a way of interpreting the language, but it's hard to know. So let's have one more musical summary here, and this is with apologies to Conrad Birdie and the rest of the cast of Bye Bye Birdie. Oh, that first sale, oh, give me that first sale. It's like the Holy Grail. I'm on a happy trail. I need the law. Oh, to give me that first sale. Oh, 109, oh, section 109, libraries need a sign. Oh, not a closed-up sign, they're following the law. Oh, give me that for sale. Copyright confirms my first sale. Copyright giving me that first sale. Oh, 1 yard sale may land us all in jail. Museums may have to shut if they display King Tut. They need the law. Oh, to recognize for sale. One for sale, one last book. Oh, give me one for sale. All right. Do I need to stop? Yes. Yeah. Oh, thank you. Thank you very much. All right, well, let's go back to the law for a minute here. Just quickly to give you an update on two important cases, Cambridge University Press versus Georgia State. This was the case in which some publishers had brought suit against Georgia State. They kind of picked that one, I think, sort of out of the blue. But the issue related to their e-reserve policies. And many courses at the school specified readings from case books, textbooks, other kinds of books, collections of essays, and they would have photocopied pages from a textbook, scanned them, and put them on electronic reserve so a student can sit in their dorm room, open up their laptop, and download or at least read the selection from the electronic reserve without having to go to the library and actually take a real book off the shelf and open the real book and actually read the real book. So this way they could do it conveniently, and you didn't have the problem which I encountered so often in college. I'd get to the reserve reading room and someone would cut the article out of the book. So you don't have the loss. Gee, professor, I was going to read it, but it wasn't there. So the case involved this electronic reserve system, and the original complaint cited that 6,700 works had been made available to students for downloading, viewing, and printing for some 600 courses at the school. Over time, the case ended up, for various reasons, focusing on 99 of these readings. The case went to trial, and at the end of it, the plaintiffs, the publishers, dropped 25 of those. It was down to 74, and the court went through each and every one of these readings and did a fair use analysis of it, coming to the conclusion that all but 5 of the 74 readings were in fact fair use. And the court applied a kind of quantitative analysis. It said, well, if less than 10% of the book had been excerpted and put on reserve, then that was fair use. So it's kind of an interesting way to do it. You know, it's not too unpersuasive the way he got at it. But anyway, that was his approach. There's still to be decided whether there's going to be any remedies or what those remedies might be as to the 5. Finally, an update on Google. You will recall, as this has been reported on several times at the Charleston conference, the Google book project had been the subject of suit by our authors and publishers, and there was going to be this huge settlement. And so last year, the court decided, no, this settlement is not acceptable. And there was a ton of criticism of the settlement, and the court finally decided, no, it's just not. So you guys go back to the drawing board. So the first thing that happens is that the Authors Guild moves to certify the case as a class action. The judge, the judge agrees. So the case right now, the Authors Guild versus Google and the Google Book Project, is going forward as a class action. The publishers, however, decided that they wanted out of this. Number of reasons, both practically and legally, why they wanted to get out of it, but they ended up entering into a settlement agreement with Google, the terms of which are confidential. It's not clear exactly what it is, but basically Google is allowed to digitize all the books of the publishers that have settled, and they can give, in return for doing this, they give the publishers the option either to allow their book to be part of this digital system or not. If they allow it to be, then they get their own digital copy of their own book, which is of some interest to them because a lot of these things are actually out of print. But that's about all we know about this. And in this particular circumstance, the court does not have to do anything about this settlement. It doesn't have to approve it because it's not a class settlement. Whether the ongoing case with the authors may end up telling us more about what the publisher settlement is, I'm not sure, but it might. So that's the situation with that, except that the Court of Appeals has entered an order staying any further proceedings at the district court level because Google has appealed the certification of the class. And so the Second Circuit Court of Appeals is going to decide whether or not the court was correct to certify a class and to deny Google's motion to dismiss. So that's the status of that. In the interest of time, I won't share the songs that I've written for this. So, I really, well, maybe later afterwards at the bar. But thank you all very much.